Ladies and gentlemen, it's top of the hour. Thank you very much for taking time out of your day to attend this seminar offered by the Royal Alberta United Services Institute. My name is Joe Howard. I'm the president. Welcome to everyone. In particular, welcome to Lieutenant General Retired Joe Berger III, former Judge Advocate General of the U.S. Army, and I guess a graduate of West Point. Joe, glad to have you here. Accompanying Joe is Brigadier-General Retired Ken Watkin, graduate of RMC. And I understand you were a contributor along with Mike Schmidt from the U.S. Naval War College on the Talon Manual on Cyber Operations. A great read, Ken. Thank you very much. Your contribution was welcomed and useful when I used it for my doctorate. This evening, we're going to talk about the rule of law and its strength as a vital national interest. By way of background, in the previous 4 months, RAUSI has looked at national security strategies of any number of countries, and one common goal was to advance and protect that state's vital national interests. We can spend all day thinking about what they are and aren't, but we've decided one vital national interest is rule of law. And to that end, I'd like to give the floor to our two guests and say, gentlemen, what can you tell us about rule of law as a vital national interest in either a global context or maybe in the differentiation between a Canadian context, Ken, and an American context, Joe? Gentlemen, the floor is yours.
Yeah, thank you very much. Look, to really talk about the rule of law, you have to go back to, and for states, you really have to go back to the Treaty of Westphalia, sort of starting at the beginning in many respects, sort of the rise of the nation state. And perhaps not surprisingly, with that came the birth of international law, as has largely been understood. So, back at the time of 1648, you get different types of political structures. One is the internal structure to a state, and one of the terms that's been used for that is war, private war, where the sovereign had to maintain control over violence internally. And with that resulted a number of mechanisms to do that, eventually working its way into police and law enforcement, prisons, education, and control. And with that came the notion of human rights, because the state has such coercive power over the people that are living within the control of the sovereign. Indeed, John Keegan, the British historian, said that the civilized societies in which we best like to live are governed by law, which means they are policed, and policing is a form of coercion. And so to protect the citizens from the government, developed the notion of human rights. But on the public state-to-state side, and when you think of right now, there are 193 member states in the UN. It's a much smaller group, but a group that has tremendous power and potential for tremendous violence, and therein developed a different form of control over force, the law of armed conflict, or international humanitarian law. And then the third type of violence that sort of developed, of which there's a body of law, is internal to states between the citizens and the sovereign, where the citizens rise up to change the sovereign, and you get the notion of insurgency, and with it counterinsurgency. So you get those three types of war: private war, that mixed war I talked about the last, and public war between states, and with them those corresponding sort of notions of law that are to govern each one. So, Joe?
Thanks, Ken, and it's great to be here this evening. Really, part of where we go tonight has to take into account the difference in the rate of evolution as well as the timeline over which each has evolved, right? That which governs internally has had much greater time across the spectrum of things that are governed internally for states than the interactions between states. And even though we can go back to the Treaty of Westphalia and talk about the origin of the state and privileges and rights of states, it is in looking at things like whether it's the Magna Carta at 800 plus years old, whether it's looking at the United States Declaration of Independence at 250 years old, and our Constitution that followed a few years later, right? a long, long history internal to most states. Now, even with upheaval, even with coups, even with changes in states, much of that body of law within a state has had time to grow, mature, and at a frequent rate of being tested. If you compare, for instance, the number of criminal cases in a single county in the United States, you may end up with the same number of cases that over time the ICC or the ICJ has heard in 75 years for the ICJ. And so with that rapidity internally to a state, you get a much better developed body of law and the policy that comes with it. And a lot of times folks don't think about that key distinction because the durability of the law, the enforceability of law domestically, the ability for people to recognize certain normative behavior within that law, because it's had a greater time to develop, is frankly stronger and more powerful in most cases. Between states, because quite frankly, those bonds and those structures are so much younger and have been tested so many fewer times, they just simply aren't as mature. And so when people get frustrated sometimes wondering why we can't better control the behavior of states, right? Think about the difficulty of a state just controlling the behavior of its own citizens in many cases where it has authority. And then you look at an interstate model and all of a sudden you're relying on voluntary compliance in a young and immature system. And that's a fundamental distinction that I think helps frame a lot of what we can talk about this evening. Ken, thoughts?
Yeah, certainly. I mean, one of the key points that's sort of underlying what you've been talking about, Joe, is the different sorts of mechanisms of governance. And the mechanisms of governance are clearly better developed internally within states. And that includes the court system, the criminal law system, the way of resolving problems within states. The same doesn't exist internationally. So you mentioned the International Court of Justice, the sort of UN-appointed court, and more recently we've had the International Criminal Court, and before that the series of tribunals that sort of grew out of the post-Cold War period to deal with war criminals. But this notion of there is no international government per se. There develops a mechanism for dialogue, and this becomes one of the issues with respect to certainly international law. It's the language of dialogue between the states in terms of how they organize themselves, but it doesn't carry with it the sort of same structures of governance. And as you've noticed, as you've indicated, they develop differently or at a different sort of pace. But one of the things to stress is that the whole notion of controlling relationships between states, and particularly in an armed conflict context, is that it's a political decision ultimately. It's states that largely decide what the rules are going to be between the states, and military forces have always put constraints on how they act, whether they are politically driven. And one of the things I like to say about the law is the ultimate political act. When you think of decisions of legislatures, they create a law, but it's after this dialogue that can include both ethics and sort of politically where you want to end up, and the law provides a level of certainty. That's happened between warriors in terms of how they conduct themselves. It's some ways historically self-regulating, but with the development of the nation state, it develops a sort of an international law perspective. And along with that, states became capable of tremendous violence by the late 19th century. They started to realize a need to control what they were doing or capable of doing to one another. And in the late, sort of mid to late 19th century, you see first with the Lieber Code in the U.S. Civil War, but later on in terms of the Hague regulations, you see states starting to acknowledge that there should be constraints on how they fight one another. And that's just one of the bodies of law that deals with the whole notion of interaction between states and military forces and defense. Oh, Joe?
And Ken, that evolution over time from the mid-19th century forward really started to lay the groundwork that was so critical for states. So we could jump to 1928 and the Killiney-Briand Pact and an attempt to outlaw war. We certainly know that has not been successful, but what that did was lay a foundation for establishing that an aggressive war is unlawful. We'd see that later codified in the UN treaty. We see that in the basis for invocating Article 5 of NATO and how we react to and how our allies and partners react to, in support of, and in coordination with each other. And so even though over time many of those systems have struggled, have failed, the League of Nations, the Kellogg-Briand Pact, and even the UN, although it endures, still struggles, right? We have a Security Council that holds the ultimate key to power collectively, built on a model of allies at the end of a war who then have spent virtually every year since not as allies, not as partners, and quite often, if not in open conflict with each other, in indirect conflict with each other. And so there are some problems, some challenges in these models that also hinder when people get frustrated and wonder, why is it that we can't force states to do X or states to do Y? It's taken multiple attempts, again, over recent history. We go back to, Ken made reference to the Lieber Code, the first attempt to codify, right, what was permissible behavior and what was not. Successful, still endures, lays the groundwork for us domestically in the US and beyond that internationally, but it didn't solve everything, doesn't address everything, and can't address everything. It's the same reason domestic law continues to evolve in common law states, because it has to address the changes in the vagaries of time and facts and situations. And the same thing plays out in the international scene between states. Ken?
And let's look at what brought about these sort of, as you mentioned, the Kellogg-Briand Pact, the UN. This wasn't a bunch of lawyers sitting around saying, I think we need rules. This is the states themselves that are forcing this. And, what brought on the whole idea of, as you mentioned, outlawing war was a World War I that killed 11 million people, right? And so the focus after World War I was not so much on the regulation of warfare, it was to try to end warfare or at least limit warfare. And so that's where you get that focus between World War I and World War II. It was unsuccessful, as Joe mentioned. And what was the result of that? The international community bringing together the UN Charter but that came after what period? 50 million civilians killed. So this notion that states are capable of incredible violence and death and destruction, and the states themselves realizing they need a mechanism with which to try to limit armed conflict, limit going to war. And so you get a framework put in place that has prohibition against the use of force unless guaranteed by the UN Security Council. But in there's also a provision that allows states to react in self-defense. And so post-1945, this becomes the dialogue. But it really is certainly untrue that war was outlawed. Indeed, one of the great fallacies, or one of the great concepts or fallacies, I guess, of the Cold War was the Cold War itself was very violent. Some 20 million people killed in the various conflicts that sort of between East and West and sort of various parts of the world, and a sort of new type of conflict emerging, and that's the change of colonial powers and empires. And with that became a desire to once again try to regulate conflict, and in this time trying to regulate sort of the internal conflicts, the wars of national liberation, the insurgencies, and try to limit violence and particularly protect civilians. But again, it's the states themselves that are the genesis of this, although increasingly you're starting to see civil society by the 1960s, citizens coming forward and saying, this is enough. We've got to form some way in order to regulate what we're doing.
Now, Ken, that's a great point and a great segue to that discussion about really who the players were and why. Because if we go back to the critical question, right, why is the rule of law a vital national interest? Right, the more rules that are in place to limit a state's behavior or to limit a state's options as a state may view it, right, then becomes a limit on that state's power. staying away from the Melian dialogue, right? And the strong doing what they will and the weak suffering what they must. The reality is that evolution occurred. It was soldiers and states defining the rules. And then as we moved forward, again, as Ken pointed out, you get into the 60s and beyond, and now you get other players in the mix, if you will. So the Ottawa Treaty and landmines. And the United States opinion, for example, that we're going to keep landmines in two places on the island of Cuba and on the Korean Peninsula. Stop the robots. And any of a number of initiatives by non-state actors and not by soldiers in an attempt to limit behavior. So for states, these are critical things to, one, fully understand, two, to be engaged in, and in some cases, three, to push back on if we are to look at the rule of law and external attempts to impose a rule of law on states from other non-state actors, then you can start to see where that rule of law really is a vital national interest to the underlying point of this evening. Ken?
Yeah, and that sort of highlights what sort of the nature is the difference about sort of international law versus domestic law. Um, when Parliament or Congress, enacts a law, it's very clear. It's a sort of an expectation. There's a central government that, whether, in our case, a federal government, whether it's provincial or whether it's federal, which sort of, in your case, I guess as well, state or federal, creates this scenario of the expectation that it will be followed with clarity and the mechanisms to do that. That doesn't exist on the international scene, and this gets back to the nature of what international law is. It is, as you've mentioned, a normative regime. It's also the language of it's the mechanism of speaking to one another, states. It creates expectations. It doesn't have the same ability to enforce in terms of how states will act. And indeed, one of the fascinating things about international law is that it works so well in terms of states communicating to one another. It's definitely under duress right now, in terms of seeing bad actors, or the view that international law is being breached or it's failing to control states. But we're nowhere back to the late 19th century, when there was virtually no control on what states could do, because now there is a language of dialogue and there is a language of expectation. And even when you see states do something which is seen as viewed as against international law, or viewed against what the normative behavior should be between states, that state quite often responds with the language of international law to explain why it's acting the way it is. It's an underpinning the dialogue between states, this sort of in some ways self-regulating as to what the expectations are. That gets to questions like, Russia in the Ukraine-Russia war. Russia is clearly violating international law, annexing Crimea, annexing the Donbass. It's clearly, taking children away, forcing, really ignoring the laws of occupation in occupied Ukraine. So the question is, why bother with international law? And the answer is, that's exactly why you need international law, because it sets the standard. It sets the not only the legal standard, it sets the sort of ethical standard, what morality that states expect and what people expect in terms of what the action is. It also sets the standard for potential prosecutions in terms of using the international criminal framework.
Ken, I think that's a great point about framing the discussion, because what the law really provides states, as you noted, is a language, but it also provides them a framework within which to have that discussion, which really, at the end of the day, ends up being a policy discussion, right? It is the policy gloss on top of the law that really defines a state's position. And so you can take a very tactical and practical example of pick a scenario where two NATO allies are fighting side by side, and although the laws of armed conflict remain the same for all of us, domestic policy may define within the rules of engagement how we limit or how we define or how we measure proportionality. And so we would use a tool like that we would use the law to frame the discussion. We would use a policy discussion to define the left and right limits, and hopefully within that policy discussion to define the mutual ground that we both understand and can both agree to. Now that works well with your fighting when you are fighting alongside allies and partners with whom you've trained, with whom you've developed a framework. It differs when you have clearly two states who are at odds with each other. And then you end up quite often with a friction created not so much by the rule of law, but a difference of rule by law versus rule of law, right? And what is an autocracy in a rule by law where they can speak the same language, but act very differently versus a democracy where it relies on, as we've discussed, the rule of law and the normative behavior that accompanies that rule of law.
Yeah, one of the and you mentioned sort of the whole issue of well, proportionality is an example. You know, what's the dialogue? One of the challenges certainly for international lawyers is that the public dialogue about what the law isn't necessarily what the law says, and the classic one for me is the whole notion of proportionality and targeting. So there are certainly with any sort of conflict discussions about targeting and collaterally wounding and killing civilians comes under the term of proportionality. But in reality, as you know, the term is excessive. The whole notion that the military advantage you're trying to gain is weighed against the lives of civilians, you know, tragically killed or wounded or civilian damage, it has to be excessive. And so you can get a public dialogue about a state being disproportionate in its targeting, when in reality the rules which the states have set up is that the casualties have to be excessive. This is much a challenge for the states as it is for outsiders trying to assess things, because they set a public dialogue. They're trying to meet their legal obligations, and the legal obligations are different than the political perspective on what is happening. And that clearly happens in certainly for professional soldiers and legal advisors of trying to manage the reality of what the law says versus what the public dialogue is about whether the military force is being disproportionate. But the key part is it's the normative discussion on the use of force. It isn't any or all force can be used to gain an outcome. There has to be a consideration of what the standards are in terms of the use of force. And for targeting, that is, you know, a standards that are sort of universally understood and applied.
And part of the challenge there, Ken, right, is the aspect of lawfare that can arise out of that. And so if you have a difference of dialogue about what the law says about proportionality, what the law of proportionality is with respect to civilians, an inability of a military organization engaged in combat to investigate allegations quickly enough to respond to social media, 24-hour news cycle, et cetera, you're left with outside forces framing the law in an incorrect, if not malicious way in order to undermine a state. So again, we go back to the fundamental question of, well, why is that a vital national interest? Because legitimacy for that state in its action is a vital national interest. And any attempt by outsiders, often generically branded as lawfare, to undermine that legitimacy, right? And again, it can be done by recasting, reframing, redefining terms of art and legal terms in a way they were never meant to be defined, i.e. constraining civilian deaths to any death on the battlefield is a violation of the law of armed conflict, which we know patently not to be true, but it is easy for outside entities to make that argument. And then heaven forbid there is not even excessive civilian loss of life, but we'll just call it significant or more than one loss of civilian life. And you start to see where the counter argument grows and gains strength to begin to then undermine the state and its interests in that conversation.
Yeah. One of the examples I like to use in terms of how the law sort of interacts with this sort of state dialogue and really sort of strategically on operational success is in 2005, an Israeli academic wrote a book called "Why Democracies Lose Small Wars," and we're actually, you know, we're blessed to be we're legal advisors in democracies, so we've got some sort of true advantages in terms of looking how we look at the world, I guess. And he came up. His theory was that democracies lose small wars for three reasons. One is brutality, that your own citizens will not accept that you're being brutal. And this in many ways comes out with the notion of torture and abuse of detainees. And I read this book in 2007, and of course we'd been in Afghanistan at that point for 6 years. And I sort of looked at what was happening, not only with the UN in Afghanistan, the Canadian forces in Afghanistan, and the detainee question, but also in Iraq, obviously Abu Ghraib and questions of the U.S. military. And clearly, this is at sort of the heart of many of the issues of counterinsurgency, the whole question of brutality. The second one was your own losses, that your own citizens will become concerned in terms of how many of your own soldiers you're losing. And you might not come to a thought that that's particularly a legal issue until you think of this whole notion of how the rules governing targeting work. And they are, you have to sort of assess your military advantage you're trying to gain versus potential civilian casualties in terms of targeting. It's really an apples and oranges assessment. There is no easy way to come to that conclusion. But that's the legal test that you have to put through. Set up the scenario of weighing those two things. And so a commander may be confronted with the whole notion of, I can limit the number of civilian casualties, but creating risk to my own soldiers. This sort of trying to do this balancing and question of what's excessive, right? Or to use the sort of legally incorrect term, proportionality. Trying to weigh that, right? So that's the second one that is laid out. And the third one is, quite simply, the loss of civilian casualties on the other side. And so you collaterally killed. And you see that in terms of any number of conflicts. It certainly was for Afghanistan. It certainly was for Iraq. You can see that with Gaza. You can see it with, Ukraine. It's this whole issue of the loss of civilian life. And so these three legal sort of frames, brutality, weighing your own soldiers versus civilians, and the loss of civilians themselves, become strategic factors and underpinning how states, how citizens figure out how your democracy is faring, but also how states have to manage strategically how they're operating because of those moral and legal obligations. It sets a nice, complex scenario with which to try to manage it. And I think it lays out nicely how complex it is for the modern military commander in terms of dealing with armed conflict, but also states dealing with armed conflict and how armed conflict unfolds over time.
Ken, as you talk about the modern military commander and you think about command responsibility and how that plays out, you think about moral injury to his or her own soldiers for that commander. And it then becomes not just an issue for a state to deal with in terms of the non-fighting population from which it's trying to gain support, i.e. that is the expenditure of national treasure in terms of executing that fight for support it's looking for the international community, but in the diligence and commitment of its own forces in the fight it's in. And so when we talk about the law being about ethics, about the law deciding moral and legal or moral and ethical issues, as it does for us day to day domestically, it also does that in an international sense. And so that complexity for the modern commander goes far beyond just whether or not there's command responsibility for the actions of his subordinates. And that takes us back to the post-World War II era and famous case with a Japanese commander, Inri Yamashita, but where it was decided that there are really three criteria for a commander. And that is that the commander had effective control. There was a senior subordinate relationship, that commander knew or should have known of that behavior, and then that commander failed to act to prevent it, or had it happened already and come to the commander's attention that he or she failed to take remedial action. It's even more complex than just that for a commander, because now the commander is worried about, again, the things we've talked about, the 24-hour news cycle. The commander is worried about elements of lawfare and how that undermines the commander's worried about challenges to things he or she has done and have they appropriately investigated them. And quite frankly, oftentimes not just the challenge, but the impossibility at times of truly investigating in real time what has occurred. And so you can cite any number of instances that have occurred, whether it's an alleged strike on a target that is asserted to have had no military value and therefore to have been an unlawful target, right? From one party's perspective, the other party to the fight, or perhaps that was a third party's perspective, the other party to the fight asserting no, in fact, it was in fact a lawful target. And now that commander on the ground is left trying to both answer externally and answer internally many of those questions while still engaged in a complex fight. And so, again, we go back to the fundamental question of why is the rule of law? Why is compliance with the rule of law? Why is existence of the rule of law and an effective rule of law a vital national interest? Again, it is part of what empowers a nation's forces to be able to engage effectively over time across things that are otherwise challenged externally so that they can continue to fight.
Right. And one of the things we haven't talked about yet, of course, is international human rights law. So we've talked about the body of law that governs states going to war and the whole notion of self-defense or getting authorization from the UN Security Council that was put in place in 1945. We've talked about the body of law that governs the use of force, and that can include targeting, as we've talked a bit about excessive force and proportionality. But I did mention at the beginning this whole notion of internally human rights, that the state was capable of such coercion that a body of rights developed for the citizens in order to protect themselves from the state. Whether that's warrants, whether it's a whole notion of things. The very things we enjoy as part of a democracy is that the state can't do what it wants, and if it tries to, it can run into both legal and political trouble in doing that. The same did not exist internationally largely prior to 1945. Now that's certainly many international lawyers will tell you it started in 1945. I think the U.S. Bill of Rights and I think the rights of man in France had an international sort of flavor to it. But that said, really 1945 and the UN Charter is seen as the growth of international human rights law. And what brought that about? 50 million civilians killed, a Holocaust, brought about the whole notion that there will be rights that individuals should enjoy. This was sort of a radical change in the sort of goal of the international community because states were largely seen capable of doing what they wanted within their borders. The whole notion of sovereignty was sacrosanct, and that they could control their citizens. And so we see this development of sort of human rights law. We see the number of treaties that come in the 60s. The International Covenant of Civil and Political Rights, for example, the Universal Declaration of Rights and such. And in fact, the UN Charter itself mentions human rights law as sort of developing. And that works its way into ways of sort of international security that you might not sort of ordinarily think of. But if we go back to the end of the 90s, we go back to the post-Cold War period, the sort of unsettled, Bosnia, Serbia, Rwanda, East Timor, all those sort of struggles, even genocide in Rwanda. And you see the whole notion of the responsibility to protect being developed by the UN. The idea that under certain circumstances internationally you can intervene into a state in order to regulate its affairs. Now, Canada was heavily involved in developing that sort of theory on the right to intervene. And it has not, interestingly enough, has not sort of been taken off as itself and sort of as a document putting into effect, sort of officially, but it has had an influence, right? And the example I like to use is if you go to Syria. I mean, there's the famous incident, and I think it was around 2014, where there were red lines drawn in terms of chemical weapons and the question of whether, I think it was President Obama, and the questions whether that was one of the failures of the international community in failing to act. What people forget is that in 2018, the UK, France, and the US did react and did attack Assad's chemical weapons facilities. And each of them raised sort of a different rationale, but underpinning certainly the British rationale was the whole idea of this sort of protection of people and the concern over chemical weapons. And one of the challenges, of course, is this whole notion of, you've had the whole issue of nuclear weapons and sort of nuclear umbrellas and questions of international security. The whole question is how the world reacts to these weapons of mass destruction. And chemical weapons is, of course, one of those. And quite frankly, the world states take a different perspective when you start to walk down the road to weapons that could wipe out populations. And who knows, we may see that in the next couple of weeks in terms of this ongoing concern over Iran and the development of nuclear weapons. So that's another dynamic. And one of the questions become, is that sort of intervention almost human rights based, as opposed to so humanitarian based for sure in terms of what states decide to do and to protect populations and to protect life. It's all an interesting dynamic.
And Ken, it'd be great if it were that clean. Unfortunately, we know in the real world it's not, right? Because we know in the real world that the issue, perhaps with the theocrats in Iran, is less with how they treat their people and more with their ability and their near ability to produce a nuclear weapon, right? And so one becomes perhaps a mask for the other, one becomes an additive, multiplier for the other, but never is it clean and simple in a way that makes it easy to dissect as a law school exam question, as the real world is messy. But it is fascinating. We go back to that two things here in two different routes. One is going back to that responsibility to protect and really that evolution from peacekeeping, right, under Chapter 6 in the UN resolution into what really became known as peacemaking under Chapter 7. And the UN as an international body wading into those waters and authorizing states on its behalf to take those kind of actions, as we saw initially in Somalia with the first Chapter 7 action. But again, none of those are clean or simple, and the real world is messy. The other one, when we started talking about, you started to talk about weapons of mass destruction, right? And what we'll see in the near future. What we'll see in the near future might not be just discussions about nuclear weapons or chemical weapons, but what about artificial intelligence powered weapons that on a modern battlefield where the pace at which your opponent may throw things at you absolutely outpaces a human ability to react. We talk about command responsibility. So how do you balance longstanding concepts of command responsibility and the actions his or her forces take against leveraging tools that may become absolutely necessary on the future battlefield just to stay in the fight and not be decimated? And I think that's going to be an interesting question for all of us to wrestle with. On the one hand, it'll certainly be a question of domestic politics and policies, and we're seeing that play out right now in the United States. If you're tracking Claude and Anthropic and the Department of Defense position as to strictures that they have in place because of corporate policies that have driven them there, and quite frankly, a previous defense policy that required a human to be in the loop. And where do we go in the future? Do we get to a point that autonomous systems or semi-autonomous systems, but primarily autonomous systems, simply overwhelm the system and therefore do truly become autonomous without a human in the loop? Ken, thoughts on that?
Yeah, I'll address that in a second. I just want to go back quickly to Iran and then get to that. So, right now, of course, all the attention right now is on the buildup and the question, the negotiations for Iran getting rid of its nuclear capability and the whole issue of will or won't there be a strike over the next couple of weeks. But underlying all this is the whole question of civil society in Iran, and the questions of the government restricting the freedom of expression because it's concerned politically in terms of rising up. There's also the question about whether there's covert action in order to states taking action in order to foster that sort of civil society rising up. And I just highlight that that's at its heart in many ways that's a human rights issue. This whole idea of the freedom of expression. It isn't just the security of the state from within, as well as the question of the threats from outside. None of these threats are happening sort of in isolation. But going on to the AI one, definitely that is, if you sort of look on Facebook or you follow on LinkedIn, the international law community right now is overwhelmingly focused on AI, as it should be. I mean, one of the challenges, it's a challenge in all our lives, right? Technology changes our lives. Technology, changes the law at the end of the day, and we're all scrambling to keep up with it. And in some ways, the law could do way better than society does. You wonder sometimes whether there should be more restriction on the engineers, right, and the scientists. And there's arguments for that as well. I mean, that's some of the dialogue you see. But ultimately, international law has to deal with all these changes, and it highlights that the law is not stagnant, and the rule of law can't be stagnant. And indeed, the whole notion of sovereignty is not stagnant. This sort of idea that you're a state and you're control of your sovereign border and no one can penetrate it is in many ways a fallacy, right? And you just have to think of the internet. You just have to think of sort of the digital revolution. It is really challenging notions of sovereignty. But let's, if we were having this discussion 15 years ago, we'd be talking about drones. And we'd be talking about drones and the whole notion of, striking organized armed groups that are in other states that are, and those states are unwilling or unable to stop the threat of the organized actor, right? And this was a tremendous stress for the international legal community in the post 9/11 period. Right? What's happened? But the view was, well, this is all about terrorism, and you'll never have to worry about drones in any non-permissive air environment. Well, we're seeing that's not true, right? We're seeing that not true in a big way. Again, arising particularly out of Ukraine and Russia. And not only are states and military scrambling in order to deal with this, the law is scrambling in order to deal with this type of technology, because it isn't just drones now, it's drones that use AI. So, the Operation Spider's Web of last year, where the Ukrainians sent the trucks into Russia, and the drones came out of the back of the truck and flew and hit their strategic aircraft. AI was involved in that, in terms of doing that strike. The question is, how do you regulate AI, and how do states control the use of that technology in their everyday life, let alone in the whole notion of armed conflict? And so it is a true challenge. And so you get questions of where humans are going to be on the loop in terms of, are they going to be controlling? Are they just going to be watching? But where do humans get to make a decision? And one of the challenges that I understand AI is it's not capable of making ethical decisions. And so this will get to the whole heart of one of the key parts about law, is that not only is it a directive, in terms of setting the lefts and rights of what you might do, it also resolves difficult ethical issues for societies and sets out standards. And I'm not sure international law is up to this yet. There's a lot of work to be done yet.
No, and even when there is a human in the loop, so to speak, a human in the process, resolving those ethical issues in and of themselves can be quite challenging. I'm going to come back to that in a minute. I do want to go back to, 15 years ago, where we thought about drones, we thought about the application of new technologies. I mean, technologies involved as long as mankind has been fighting. It has evolved perhaps exponentially more quickly over the last 100, 150 years than maybe in the preceding couple hundred. But the reality is, is we have, for some great period of time, at least as long as we've thought about the law on the battlefield, dealt with technological changes that have driven us to think about whether or not we need to change the law, and does the law need to change to match technology. Go back to the advent of the balloon and the belief that if you have something in the air, therefore there must be a different set of rules as to what you can do from the air in terms of targeting, bombing, et cetera, right? Evolution into airplanes. What we found then, and I'll jump forward to cyberspace and cyber operations, right? We found going back to some of those basics of the law of armed conflict, and especially going back to discrimination and proportionality, that those gave us a strong foundation and great tools upon which we could rely. And so even in a world of rapidly advancing technology, of significantly changing technology, there exists a tool to at least frame or a set of tools to at least frame the discussion. And that's critical, but it relies on normative behavior to accept the framing of and the use of those foundational tools as a method to get to some sort of agreed upon answer. Difficult ethical issues, right? So we talk about artificial intelligence being capable of doing a lot, but it is not capable of making an ethical decision. And I think no matter what anybody says about sentient beings in a machine, that we're not there. And there's some great pieces out about the fact that we may never get there and hopefully don't. But difficult ethical issues have been a challenge for commanders, right, since time immemorial. I think of an example of a commander in Iraq who receiving an outbriefing from an operation, and part of the briefing was that a woman had gone to kill the military working dog. So the bomb sniffing dog that went on the objective with the team, a woman goes to try to stab the dog, and the soldier, the dog handler, kills the woman. Now, under the rules of engagement that U.S. forces were fighting under, as were some of our partners and allies, that was entirely permissible. To the commander who took that briefing, a 3-star that day, he pulled me as his lawyer and his sergeant major as his senior non-commissioned officer advisor aside immediately after that briefing and said, there's no universe in which a human's life is worth less than an animal, even if it's your sworn enemy. I want to change the rule. Now, right, that's an ethical overlay on top of a policy decision, on top of, right, an agreed upon assessment of how we're going to fight as partners and allies. And so whether it's in a technologically complex environment, whether it's in a simple environment of human versus dog, right, these ethical issues really do frame a lot of what it is we do and how we use the rule of law, but it relies upon normative behavior to accept that framework as a start point, regardless of the space in which we're trying to apply it. Ken, thoughts?
Yeah, one of the interesting things about you mentioned about applying the laws we have to the new technology, and clearly that's what's been done in the cyber world. Joe mentioned about cyber. Some of it works really well. Some of it creates some challenges, right, in terms of doing that. One of the interesting things about law is how ubiquitous it is in your life. So, if you think all the way, you think of everything you have here and around where you're sitting has had some sort of legal regulation that's got it there. In your daily life driving a vehicle, the vehicle itself is governed by some sort of law. In some ways that happens internationally with many things. And so, international law is under stress for sure, but there's a lot of our sort of things that are done that look at the trade system. With all the churn over the trade system, the trade between 193 states is amazing in terms of the how easily it happens in terms of an international legal framework. There are analogies to that to the military as well in terms of how states operate. So some states, may be viewed as bad actors. Some are viewed as ignoring the law. Some are viewed as trying to change the law. We can get back to that in a second in terms of changing the law. But uh, for the 193 states, for the 185 that aren't involved in the rest of that churn, it sets out some pretty clear standards in terms of how you're going to operate in sort of everyday activity. That said, I find one of the fascinating things about international law, and particularly in the security environment within which we work, there are some areas that aren't clearly well regulated, not in this in the same way there might be in the civilian side. And my work the last couple of years has been looking at espionage and sabotage, and both in peacetime and in wartime, um, there's a tremendous lack of clarity of what the rules might be. What I find more interesting, there may be a tremendous lack of interest in looking because it's such effective in terms of interstate affairs. There's always, espionage has always been part of interstate affairs, but where it comes home to roost is think of hybrid warfare and think of Russia, Ukraine, and Europe right now. And and for those who don't know, hybrid warfare is sort of a concept that has been developed to try to deal with lower end conflict where it's not clear where it crosses the threshold from just ordinary crime into actual armed conflict. And this is the buzzword if you're reading any European news right now because of the really tremendous amount of espionage and sabotage which is occurring in Europe right now, attributed back to Russia. And they're quite open about attributing it back to Russia. The problem is no one wants to go to war because of the consequences. And what it sets up as an interesting dialogue of Russia doing acts that states might ordinarily view as acts of war, deciding to choose to deal with them as a law enforcement framework. Incidents that are happening in their states for a couple of reasons. For one, the violence is low level enough that it can be done as law enforcement. Russia and other states are employing criminal gangs to do it, and so they naturally fall within a policing framework. And politically, to get states to agree that these are actions of an armed conflict, such that collectively something like NATO might respond to these threats, and the consequence of doing that has a tremendous overlay in terms of how the law is applied and how states interact with one another over these threats. Over to you, Joe.
Now, Ken, that's great. How it is framed by the state is often a tool used by the state, right? Or how it's not framed. And so you can take Venezuelan boat strikes, and whether that is a NIAC, whether that is law enforcement, which is the longstanding U.S. practice, where that falls on the spectrum and how a state responds. But to your point, right, how a state frames it drives how other states respond and drives similar behavior by other states. And so in a law enforcement context may give states, interestingly enough, more maneuver space in which to act that they wouldn't otherwise have. We look at where the evolution, where does international law come from, right? It comes from that combination of belief in what the law is coupled with state practice. And so when we look at state practice, I don't know how many times I've heard lawyers in frustration talk about non-state actors, non-governmental organizations and others, right, opine on what the law is, and then those military personnel say, hey, right, if you're not in the fight, don't tell me what state practice is unless you're out there actually practicing it. Well, that's good only insofar as it's a terse response and might have a small sense of humor in the moment in it, but it is not helpful, right? What is helpful is thinking about the law. And so, right, as we get close to the top of the hour here, I think it's really helpful for all of us as we think about this to step back and say, okay, first of all, what does the law give us? The law gives us a framework. The law gives us a framework domestically. The law gives us a framework internationally. The law gives us frameworks to deal with different things. The law gives us a framework to deal with forces on forces. The law gives us frameworks to deal with civilians. The law gives us a framework to deal with an internal population that may not be getting the full body of rights to which they are naturally entitled, right? Whether we go back to hold these truths self-evident that all men are entitled to, et cetera, et cetera. And so I do think, right, as we have talked this evening and covered quite a lot of ground, that we don't forget that critical piece, right? The law provides a framework. But on top of that framework is a policy discussion that occurs. And whether that's a policy discussion internally to define and scoped within ethics and morality as to what is permissible domestically, the same thing occurs internationally by states and between states. And I think that that's important because that's really where you have to start the conversation. And at the end of the day, that's where you have to go back and test your execution of what you're doing within the framework. Ken?
And that's an excellent point, Joe, which is states have choices, and quite often the dialogue about law is a state has breached the law, an interpretation of the law. When reality is states use all these sort of avenues in terms of that are available to them, and one of the challenges as a legal advisor is ensuring that those avenues are well explained and thought of. As options. What I would quite often say to people is, what is it you want to do that the law won't let you? There's a sort of misunderstanding of sort of the ability and scope of the law. And where for me where it comes home to roost is the whole question of a counterinsurgency, which is, you're involved in an armed conflict and you're capable of using large amounts of force. The question is whether that's the smart thing to do strategically, right? And the question is whether the state is better served to apply a law enforcement approach to some of the threats that it's dealing with. The whole notion of a counterinsurgency being police primacy, which means you're going to apply a different set of rules for a variety of reasons. And one of which is Bernard Fall, who was a famous sort of writer, once said that a country that's being subverted is not being outfought, it's being outgoverned, right? And the whole notion of the hallmark of governance, as we started with sort of internally, is the idea of law enforcement and restricted use of force and the protection of human rights. And so it is wrong-headed to engage into an insurgency only thinking in military terms. That's the way you're going to go. And what you end up with quite often, obviously, as you know, is you get a hybrid approach by security forces that mixes military and police and mixes the law governing armed conflict and law enforcement. And those are options that states and military commanders have to make. The challenge internally within a military is explaining those policy choices that on choices of law that are going to be applied. And that's quite often where, you'll see that restriction that the soldiers, sailors, and airmen don't want to be restrained in what they're doing because they've been trained to go to war. And at the end of the day, strategically, that's exactly what you're supposed to do to win and what you may have to do to win. Killing someone, their family doesn't understand that they were necessarily providing support to the enemy. The family understands that their father, son, or brother, or sister, or mother was killed. And that type of action breeds resistance. It doesn't breed what you want, which is finding an end to the conflict. But it's, again, back to that complexity on the various legal options that you might have.
And I think with that, going back to the adage of winning hearts and minds, right? We can step back from a counterinsurgency and just apply it more broadly. What are people looking for in this world? They're looking for legitimacy. They're looking for predictability, right? Those are the things you get when you fight within the rule of law. Those are the things you get when nations behave within the rule of law. And again, the law provides a framework. Normative behavior is critical to the ability to successfully and effectively apply that legal framework to whatever the situation might be. It is an imperfect system. It is like any system. It is a system made by humans, and therefore it has failings. It is a system that lacks the stick and only has some of the carrots of a domestic system. And so when you draw that comparison between behavior between states and behavior by states within their own borders, it's markedly different. There is, as we started, a difference in the maturity and the evolution of each of those systems and each of those bodies of law. It does continue to get better. It continues to grow. It continues to be challenged by new things. but it also has a pretty enduring framework at its heart that allows new challenges to be dealt with, at least as an interim step. And so I remain optimistic about the vibrancy of the rule of law, although it is under duress in any of a number of places around the world. But it takes leadership. It often takes lawyers to help defend it. It takes international actors. It takes national actors, again, doing the right thing within the bounds of normative behavior. Food for thought.
Well, gentlemen, thank you. I'd like to wrap up the first part of this presentation. Ken, you mentioned the advent of human rights. I will suggest that everybody go out and buy Samantha Power's book, A Problem from Hell, America in the Age of Genocide. So that sums it up pretty well. She documents the campaign by Raphael Lemkin on pushing through the Genocide Convention. And if you read that book and you don't cry, you don't have a heart. Last point, Michael Ignatieff taught at Harvard before coming to Canada to be a politician, but he addressed the Department of Foreign Affairs and International Trade in 1994 at the O.D. Skelton lecture, pointing out the difference between national values and national interests. But that was back in 1994. But I hear you two guys tonight, and I'm thinking rule of law is both a national value and a national interest. And maybe these two things have conflated. And while Ignatieff's presentation of 30 years ago was well crafted, maybe now it's irrelevant. But we'll save that for the bar. I would now like to turn the floor over to my good friend Quentin Innes, who's going to shepherd the questions. Quentin, the floor is yours.
Thank you, Joe and Ken and Joe Berger. Thank you very much for that presentation. Incredibly insightful and some really, really good stuff to chew on in there. Before we move over to questions, I'd just like to frame some of this a bit. We talked initially, you both started talking initially about the difference between international law and law as it's commonly understood by people. So international law covers, or attempts to govern behavior between states, and law as we normally think about it governs behavior between individuals. So for the audience, I'd like to keep the discussion at that level within that framing. Let's stay out of domestic politics and let's talk about international issues. And with that done, Fred Moret, I'd like to call on you first to ask your first question.
Good evening, gentlemen. Thank you very much for your presentation. I'm an old armored reconnaissance soldier. I did a decade and a half in armored recce, including 4 years in Germany at the tail end of the Cold War. I'd like to start to frame the question by an observation that I have about both the war in Gaza as well as in Ukraine, and that is to the erosion of humanitarian rights as far as the law of armed conflict, the deliberate escalation of targeting of civilians in both conflicts to achieve a particular state aim. One of the key things that has, I think, over the course of the last 80 years, been helpful was the idea of deterrence, because there is accountability to certain actions that that somebody may make in contravention of the rule of law. With the erosion of these humanitarian rights in these conflicts, and if we take the conversation back to the rise of autonomous AI decision making, at some point we're going to lose that ability for accountability and that deterrence, and I think that is going to simply continue to accelerate that process. We're already seeing, for instance, with AI, that AI agents can now interact together on a platform called Moltbook, and that's been coming up now for the last year or so. I'm wondering if you can comment about the future way that we can continue to hold states or commanders in those states accountable for decisions that they don't make as we're heading into these future conflicts.
So Ken, I'll jump first. Fred, the challenge is significant. I don't think that it's a blank slate to say commanders are never responsible, even when those tools are employed. Somebody makes a decision to employ the tool.
Yeah.
Somebody makes a decision to employ the platform. Somebody makes a decision to bring it onto the battlefield. There has got to be accountability at some level for an action taken. The system doesn't self-deploy and doesn't initiate action on its own, right? So I think that we need to think about that. I'm not going to disagree and say that it's a hard problem that we'll have a harder time. The connection may become more tenuous, but that becomes a question of other states' normative behavior response to it, right? Not just the state itself. But again, if international law is a function of a belief in what the state of the law is and state action, how states respond to what other states do, how states respond to what other states do is critical in the evolution of that law. And I think that will be a critical piece going forward. Ken, thoughts?
Yeah, well, I mean, one of the requirements of the law, it has been a requirement since the 1977 Additional Protocol 1 to the Geneva Conventions, is that there be weapons reviews. And there's a lot of this going on right now within certainly responsible states. I mean, you can't control what all states do, and that is assessing exactly how do you control these things. And so there's various ways that we'll look at in terms of where is human input. Is it human input monitoring it and looking for errors, or is it upfront in terms of how you design it? And if that weapon is incapable of technologically from restricting itself in the right situations, then it shouldn't be approved. And of course, there's a tremendous pressure that other states are developing, or actors who aren't responsible, who are developing the means to attack. And the question is how you react to that, right? But there is a legal framework within which to consider these things. But as you can imagine, and you'll know, the speed at which cyber works, it's impossible to say that a human will always be involved. And so, because the attack will be over before you can react, it is creating tremendous stress, but it doesn't mean that there isn't an answer. What it requires is for the lawyers and the technical folks to get together and find an answer that meets those needs. It's not easy, but it's also not impossible.
Thank
And
you.
on that, I think there's significant pressure on those lawyers who are part of that team conducting those weapons reviews as the speed of technology increases, as the technology becomes more complex, and as the lawyers have to have a greater degree of understanding what that underlying technology is so that they can truly help assess. These are hard and difficult things, and are requiring new skills for longstanding lawyers with a strong background in international law. But I have seen firsthand some of the technological challenges and some of the technological education that's been required for those attorneys to help them understand that. So, Fred, it is a complex problem, but to Ken's point, there are a number of safeguards built into the system that as long as we don't blow past them, and again, back to normative behavior.
There are also some various avenues available to do this. So one of the responsible companies are understanding that they want to be human rights compliant when they embark on certain activities, in particularly for simple things like employing security personnel. Right, you want to be able to ensure that they're operating properly, or it carries a liability. And been a fair bit of litigation in terms of providing weapons to certain countries and actors. There's actually some private initiatives for individuals to get involved with companies up front to meet the legal requirements in terms of some of these AI and other weapon systems as part of their business case. So in other words, when they go to the state that they want to sell their wares to, they're able to say, we considered all these issues, which we know you're going to look at in terms of deciding whether this weapon system meets your legal obligations.
Fred, does that meet the mark? Does that answer your question?
It certainly does. I think that the gap that we're going to see, and I think it's been mentioned, the gap is when responsible states do the right thing, and then other actors decide that that's a weakness and they don't do that right thing.
And perhaps we're already seeing that with Russia, Ukraine, right?
Exactly.
Okay. Ken, Joe, anything to add to that?
I think that's good for me, Ken.
Good.
Yeah, no, I'm good.
All right. I'd like to shift over to Daryl now, call on Daryl to ask a question. He talked about sort of the practicalities of how you do this. How do you give advice under pressure, I think, is where we're going with this. Daryl?
Yeah, thanks. I didn't expect to be front and center on camera this evening. So I'm going to put my bias up front because my question is about your bias, right? Because that's important. You guys are people. Irrespective of stars and degrees and experience, you're people. And that's the heart of my question. My cousin, a former JAG of the Canadian Armed Forces, but we are second cousins. And my entire time in the Canadian Armed Forces, 26 years, was in the infantry. So two different, perspectives, not only on operations, but two different perspectives on bias and what that means to me. My, operations clearly had a different intersection whilst I was overseas compared to my cousin. How did your bias play into this? Like a great conversation that you had, I listened intently. It was wonderful. But how do you separate the human from the job? Can you, especially on international operations, how do you do that?
Yeah, I'm not sure which bias you're talking about. We all do have biases. I agree with you.
Your personal bias, Ken, your personal
Yeah,
bias. So the commander, you make a recommendation because at the end of the day, you make recommendations.
sure.
The commander may or may not go with that, or commanders famously go with the third or fourth option that we never thought of, right? So how do you reconcile that? How do you, provide that great information and put your bias aside on that specific element? Does that make
Yeah, I mean, I'm not sure all biases are bad, first of all. So I guess the question is, in terms of my approach, I mean, I looked at it a number of different ways. I think many do. Is my job was to keep the commander, keep the Canadian forces, keep the Canadian government within the bounds of what I understood the law to be and what the requirements were, right? And so, what one way to do that was, my view was to create an operational envelope within which decisions could be made. And I think that gets down to the question of discussing with them, what is it you want? What is it you want to do? First of all, you need to be integrated in what the operation is, and what is it you think the law won't let you do? Because the law is tremendously flexible. That said, the bias is, and this is one of the challenges of being too integrated in the system, that you're not objective enough. And I think that's where a concern of a bias comes up. There's various ways that can be addressed. I mean, certainly in our approach was the military lawyers aren't on the staff of the military commander. All military lawyers in the Canadian Forces answer to the Judge Advocate General, who answers to the Minister of National Defense. And the Judge Advocate General is an order and council appointment, as is the Chief of Defense Staff. So there was definitely an independence there that's built into it. That said, people from outside the military could look at it and say you're wearing a uniform and therefore you're naturally biased, right? And so the best way to do that is to both study and be aware of what the law is. Interestingly enough, one of the biggest challenges that I saw in particularly on the operational side was dealing not so much with the military and interaction with the law. It was dealing with the the academic and the outside understanding of what the law was, and the education side to educate people who were being civilians as to what the legal perspective was. But anyways, that's the best way I know to do it. You have to be true to your ethical obligations, true to what you understand the law is, and be open to be challenged by your own people. Interestingly enough, that helps with the bias.
Yeah, Daryl, agree with everything that Ken said there. The education piece is critical, right? We train for the known, we educate for the unknown, and you really have to do both. For lawyers, there are known problems you'll face, facts may change, and then there are the unknown problems. And so that piece is critical. We talked about the fact that lawyers advise and commanders decide. Countless times I had a debate with a commander, right? And sometimes I truly played the antagonist just to get him to think through. But sometimes he played the antagonist back to me. And part of that was honest discussions we had about how best he received information, processed information, and wanted to be able to make a decision, right? So understanding your client, right, at a very, very basic level. But Ken raises a bigger point, and that is part of the biases are eliminated by being part of a larger process, right? If you start at the very beginning and look to the commander and say, what's the problem you're trying to solve? Don't ask me the binary question you want an answer to, because if our relationship is you coming me solely seeking answers to binary questions of may I or may I not, you've probably already made a series of decisions that have backed you into a corner of may not. It just statistically sort of happens that way. Versus if you, the lawyer, are part of the planning and decision-making process, a lot of those biases, I think, get flushed out through that process because you have any of a number of things, not the least of which are red teaming, to help you think through them. And so I think a lot of it depends on the vibrancy of the education process, the relationship of the attorney to that commander, right? And then the process that the attorney embeds him or herself in to facilitate commander decision making.
The other thing I would add with that is I found it an incredibly open environment within which to give advice and discuss with commanders. I mean, it's all time constrained. You know, there's never enough intelligence, as you know, when you go to do something, right? There's never enough time. But I was, you know, constantly pleased with the discussions, the intelligence, the folks don't get to senior level of command unless they can deal with complex issues, right? So it's that as well. But even at the unit level, in dealing with folks want to do the right thing at the end of the day, and they quite often recognize that the law provides some certainty where they're headed in terms of what's ahead. So it was never really much. I certainly didn't see it as much of a problem in terms of giving advice.
Great.
Daryl?
Thanks for, Quentin. Thanks, gentlemen, for your responses. Outstanding. Thank you.
Yeah. And I think this speaks to the importance of process. And process is one of the ways that we avoid getting sucked into those personal biases. So on the note of process, Kevin, I'd like to call on you next. I see you have your research assistant with you as well. Nice gray cat. But I'm going to hand the floor over to you and talk about what's the reality of the IJC and the ICC. I mean, we have these processes in place. We have courts in place. We still get decisions made or things happen that we disagree with. So, Kevin, is that good framing for your question?
Did that work?
There you are.
There I am.
There you are.
I think you summarized it pretty clearly. My big concern is every time we have decisions that go to the UN that the major powers don't agree with, we really don't have a way to either compel them or influence them into accepting, debating. They just, like if we go back to, I think it was Nicaragua and the United States, where they were brought to the UN, ruling came out the Americans didn't agree with, so they just withdrew. Like, how do we get nations, encourage them to come along there and play well with each other? I was in the military 33 plus years. Seen it work well internationally, seen it work very badly internationally. people are good, governments are sort of where it falls down, and then it's for the military to clean up.
Yeah, the Nicaragua case is an interesting one. It's a great case, actually, in many respects. The people don't really remember the Nicaragua case for the U.S. having withdrawn. People remember the Nicaragua case for the standard that's applied in terms of armed attack and the gravity of armed attack that's required for lawyers, anyways, to deal with, in states when they're trying to deal with the whole question, what they are allowed to react to in terms of an armed attack. And one of the challenges of states not engaging is you may not like the outcome that you get out of the trial, right? In terms of the standard that's being set because you haven't influenced it. And so that definitely is an outcome. The ICC is an interesting scenario because, of course, it didn't just pop up on its own, right? And so you have to go back to sort of the end of World War II and the various tribunals then, and the concern of victor's justice. But there was a notion that this was bad enough that there was going to be some form of justice, and it's quite open historically that one preference would have been to simply execute all the German high command rather than try them, right? But they went for the trial, for a reason, right? Because that's also the expectation that we have as societies and humans, that there will be some form of accounting in all of this. And it didn't just appear, in terms of the ICC. And even in our own legislation in the early 80s, where we were dealing with war criminals in Canada, right? So one of the first things I did when I joined the JAG branch was I was involved in briefing the new Department of Justice War Crimes Unit on the law of armed conflict as they were standing up. And so that's the early 80s. We get to the 90s, and what happens is Canadian personnel are involved in the expert commission that's looking at Yugoslavia and the war crimes there. And there are lines that are crossed. And the question is one of the things I used to say all the time was, if soldiers do something wrong and the commander does nothing, what's the message they send to the soldiers? Mm-hmm. You either condone it or you don't care. Right? And either way, that's problematic, right? It's problematic for discipline. It's problematic for operational success. It's problematic for them personally at the end of the day, if that's the message they take away. So we had these series of tribunals in the 1990s that led itself to the ICC. The ICC is definitely controversial. There's no doubt about it. International tribunals are, by nature, in terms of controversial. They're taking, and the most recent, taking steps in the midst of armed conflict to begin to arrest people and to begin cases is very much an experiment in a way. In terms of what effect it has, and there's articles out now. The jury's really out as to how effective that is and how wise that is. The bottom line is you can't do nothing. I guess that's the message I send away. You have to care, and you can't condone it. And so the question is how you deal with it.
The only thing I would add, Ken, in addition to Ken's commander example, right, about a new standard has been set. Same applies at a national level, right? A state that steps away, a state that ignores, has set a new standard. But you have to think about the full spectrum of tools that a state has available to it, right? Compliance may be achieved through another means, longer over time, through economic sanctions, through diplomatic activities. The law itself and the way we think about it in a domestic context of some entity that could come in and enforce it, i.e. the local police, right? Whatever that might be, just doesn't exist internationally. And so other tools may be necessary by other states to either individually or collectively, right, force a state into some degree of compliance. And so again, I think a lot of it goes to the difference in maturity and the fact that we are assessing one system, the international system, right? Go back to biases, inevitably through a bias, right, for an effective or a more effective internal system within our own states. And that's probably not a very fair assessment. It's probably not a very fair metric against which to measure it. And so that makes it a little easier to be frustrated by it, perhaps let down by it. But I think that the reality is the systems continue to evolve with some degree of health, but it takes time.
Yeah. All right, Kevin, does that answer your question?
Yeah, no, it's great. Oh, am I on?
Yep, you're still on. Yep, you're good.
Sorry about that. Don't have my glasses here.
Yeah.
No, I think those are good answers. Certainly food for thought. Like I say, I've been in the military long enough. You kind of hope for the best possible outcome, but we don't always see it for a number of reasons.
Mhm.
And that's always just sort of been in the back of my head with everything I've ever done and seen. So thank you all, gentlemen. I appreciate your answer to my question.
Good stuff. Okay, cognizant of time, I know it's 10:30 on the East Coast. So, gentlemen, great discussion. And Joe, I've written down a couple of quotes from you. If with your permission, I will steal a couple. Train for the known, educate for the unknown. And I think our last question here from Basir is going to take us into the unknown because we're going to talk about, or I think Basir's question is going to be about lawfare and how it relates to that mixed kind of environment that Ken talked to about at the very beginning. So, Basir, over to you.
Thank you very much, Quentin, Ken, Joe. You have all been most wonderful, and they have actually explored quite a bit of unknowns themselves. So we have to live up to high standards. Lawfare hijacking it happened throughout hybrid gray zone, and it's continuing to happen. So disrupting functioning of the government mill and in a way, AI is also the prime target in the sense that codification of the law, enforcement of the law is kind of a turn against the military. I have witnessed multiple instances where, the higher standards is only meant to, in a way, restrict the military. I guess, obviously, we are cognizant of several rival countries developing very hostile and aggressive AIs, and obviously our, let's say, weapon system AI should be able to stand against it. But then in a way, there's a strong effort. So I don't know if you have ever come across it, or whether it's in the public domain or just in general domain or a concern. Thank you very much.
Okay, lawfare is it's a difficult term. I'm not a fan of it in many ways because from my perspective, states rely on their lawfare as much as the critics rely on it, right? So it's you go out there and you say, well, of course we comply with the law. Of course we are, leading. This is all sort of out there. And of course, the alternate on the other side is, you're being criticized and for failing to meet legal obligations. What's missing from much of this dialogue is what the legal obligations actually are, right? And so I guess at the end of the day, the best defense to that from a lawfare perspective is to clarify what the obligations are in terms of what standards you have to meet. That's a challenge. That's a true communication challenge. This comes up quite often when a conflict starts, and then the question becomes on civilian casualties, right? And what's missing from the dialogue is what's the military objective that's been trying to reach. I mentioned earlier it's an apples and oranges question, and if I was to ask you, how many civilians is it permissible for you to have killed in order to kill this senior commander? And you'd have to think that through and figure out, how do I weigh that? One of the challenges in the law is exactly that. The military advantage to be weighed, and international law doesn't give you an answer. What international law does is it sets out a process for you to follow. So the first thing you have to do is you have to figure out who is a civilian and who is a combatant. And you can target combatants and you can't target civilians. The next thing it says, you have to do everything feasible, right, to avoid killing civilians. I mean, this is missed from the dialogue. It isn't just not excessive casualties. Your first obligation is to avoid them altogether. And then you go to the question of try to minimize those casualties. And then at the end of the day, you make this assessment. But there's no easy assessment. And one of the most interesting, I think, well, there's a number of interesting things about international law, is the lack of case law after all the killing that's taken place, since World War II. The lack of case law, and particularly since 1977 when this test was developed, as to what that test is. And you would be hard pressed to find prosecutions anywhere for having created collateral casualties. Because at the end of the day, it sets a process where you take through the steps and you reach a place where you're comfortable, that makes sense. And the ability of the commander is exactly that, to answer back with some level of comfort that they followed the process, and this is the thinking that brought them to that place. How you put that in a lawfare discussion, it gets mixed. But I mentioned one of the challenges is this dialogue, right? This dialogue that happens in the public is different than happens when lawyers get together to discuss what the law actually says. And that itself becomes a communication problem for states constantly. Anyways, that's the best answer I can give you on that. For the AI perspective, I mean, we're bombarded, right? Our children are bombarded in terms of what's true, what isn't, what is right, what's wrong on social media. Coming out with sort of little hints as to what might be an AI generated image. That it's going to be left up to the technical guys to do that. I'm just a poor lawyer trying to deal with the outcomes.
Thank you very much, General, sir.
So, Basir, the only thing I would add, right, I'd reinforce what Ken said about process. I think process is your greatest weapon against allegations, whether you're categorizing them as lawfare or anything else, right? Process and your ability to talk through adherence to process is your greatest tool and your greatest response. The reality is this is as old as man fighting each other, right? And it's lawfare is sort of a subset of broader propaganda with just a more recent name, perhaps, and a greater cult following to it. I'm with Ken. I share some skepticism over the label, but I think that any attack on forces and how they behave, and again, how a force behaves time and time again, repeatedly over time, sets a foundation that makes it easier to use process to your defense. And so how professional an army is, how professional a force is consistently across various battlefields matters, right? And then what that force does to clean up its own ranks when it has problems, right? Does the force hold people accountable? And does it take corrective action? Not just, right? So very famously in Vietnam, after the My Lai massacre, right? It was a core level, a 3-star headquarter level cover-up for over a year. But when that investigation was finally done, that's when the US military began actively training soldiers on the law of armed conflict from the very beginning. We had massive culture change within the US Army to great effect over time, right? To great effect of soldiers knowing the rules and soldiers holding other soldiers accountable. And I think that matters as much as anything else.
Yeah, and just to reinforce that, I mean, I think Canada saw its own example of that post-Somalia, right? So not only did we have criminal investigations, we also had a board of inquiry. I was the legal advisor on the board of inquiry that looked at the Canadian Airborne Regiment Battle Group, the public inquiry, and it's that whole issue of being committed to accountability, as Joe mentioned, which is key, and it's your best defense. In other words, we will investigate if the complaints are made. The challenge is speed, right? And many have you been in the military? We used to say, well, it's about the third message from the theater before you really get the facts, right? and the first message is what the media is spinning up on. And so the question is how quickly you can react to that becomes one of the true challenges. What you can do, though, is you can build up trust that you will react. And I think that's your best defense in all of that, as Joe says.
I can attest to the high standards the military, I mean, I'm not a military guy, but I can attest the high standards the military is holding. The problem is obviously kind of guerrilla lawfare leveled by some lawyers. Over. Thank you, sir.
Okay. Thank you, Basir, for that question. Does that answer your question? Great.
Yes, Crystal, everything.
Okay. Gentlemen, I think we can wrap up at this point. I just want to pass back to Joe Howard to do the final comments. And from me personally, this has been incredibly interesting and incredibly informative. Thank you very much for your time.
Thanks, Quentin. Yeah, this was gold standard stuff. You don't get this too often. So, Joe and Ken, thank you. And that is from the heart. This is just great stuff. Rule of law is a vital national interest. I also think it's now a vital national value. And I'm not sure I'm going to be able to make the distinction. And maybe you can't. With that, before you go, I'm inviting you all back next month to talk about another vital national interest. And that is the sustainability and the independence of a central bank. These are the guys who either make your life great or make your life miserable. Canada's situation is not too bad, but in the United States, there are parties who want to direct how the central bank works. And the poor chairman at the moment, Jerome Powell, is subject to attack from any number of quarters. Our guest next month, is a guy called Don Cohn, a former governor of the Federal Reserve, and a guy called Paul Baudry, who's a former deputy governor of the Bank of Canada. How a central bank runs is a vital national interest. And I hope each of you will come back. We won't make it too technical, but these guys either put money in your pocket or they send you to the food line. And on that, thank you very much. It's late on the East Coast. Appreciate your time. Ladies and gentlemen, this meeting is adjourned. Have a good night.
Thanks, Ken. Thanks for the dialogue.
Thanks, Al.